That's kind of how we started, and we're branching out into some other areas, but it's really a lot of our work is for companies who are scaling around some core intellectual property assets.
Awesome. Well, excited for this session, and the floor is yours.
All right, fantastic. Well, hey Louisville, very excited to be here. Happy lunch hour to you, and for some of you, happy workout hour. We are, as Mike mentioned, Rockridge. We have offices in Nashville and thanks. So our firm was started a few years back. I launched the firm after relocating from the Bay Area, where I just really got into entrepreneurship and technology commercialization, and wanted to start a firm that had a commitment to triple bottom line practices. And so when we launched, we sought B Corp certification. So we are one of the only B Corp law firms in the South. And for that reason, we really love working with social enterprises in particular. And so we'll kind of talk a little bit about that as we go on. Some of the IP aspects that are critical to entrepreneurs, particularly in the social enterprise space, e-commerce space, areas like this where you have a lot of touch points with your consumers. So that's me right there. So, and just below, a little shout out to Make Mom Proud. I have various hats that I wear. I am a patent attorney. I do work in the technology space. And then also for companies in corporate respects and various aspects of IP around entrepreneurship, helping companies just to prepare for growing and scaling and conquering the world. Bruce, next slide. We also have Lauren Hughes today. She's going to introduce herself a little bit later on. But Lauren is one of the only certified information privacy professionals in the state of Tennessee and probably the South. And so as you all may know already or will learn today, privacy is touching upon all of our businesses and operations. Pretty much every state is passing privacy legislation now, how you can handle consumer information, what you can do with it, what restraints you have on using that information, both for your own company, for third-party businesses. So really exciting practice area. Next slide. So a little bit about Rockridge. We'll go ahead and skip this. We already introduced ourselves. Legal disclaimer, this is for you, Jake. All right, so if you're watching this while on a scooter, working out, doing anything crazy and you bust up, we're not responsible. Next slide. All right, so IP basics. I like to call this sort of conceptual plus. I'm really gonna hit the high points, but do a little bit more characterization of why this matters, what kind of IP fits into what category and why it's important for your business. Next slide. All right, so what kind of environment are we in today? Well, in particular, a few things that I want to highlight. We're in a day and age where a lot of us are having to do business online. Obviously, we're all joining this call, Zooming. It's become a part of our daily activity is getting on some sort of video conference. A lot of us may have been operating primarily in a physical space, but now we're having to launch online and productize whatever our business model is online. And when you do that, you're going to run into lots of IP issues that you haven't had to worry about before. So I've got some references here in the slides, and so you can visit these links if you reference the deck later. But we've got copyright trolling activity where we've got automated bots out there scanning the internet and looking for images that might be copyrighted that you didn't know about when you or your designer built your website or built your app platform, and they may come shake you down for pretty intense royalties and penalty payments for infringing upon copyright rights that you didn't have permission to. Trademark bullying, lots of trademark bullying out there. We are tangled up with one of the biggest bullies right now in one of our cases. So trademark bullying oftentimes involves resource allocation and resource inequality. So if you are not trademarking your name early, then watch out. If you get behind someone else who trademarks before you, then you've got a lot of issues that might cause you to rebrand, very, very expensive rebrand. You might lose your whole market. You need to watch out for companies that have heavy IP portfolios, even nonprofits. A nonprofit like the AARP, American Association of Retired Persons, they even aggressively monitor their trademarks and enforce them against third parties. Taking into consideration all these things, there's a very, very active space, and IP is important where you might not have thought about it. Next slide, Bruce. The IP in e-commerce is silent. I like to say this because when we are working with companies, when we first kind of get to know our clients and understand what their business models are and what they're going to be doing, a lot of questions come up, and here are just examples of those questions, and why we need to kind of do a little bit due diligence and distinguish what the different categories of IP are and why they might be important for entrepreneurs like you. So what's the difference between a copyright and a trademark? What's copyrightable or infringing about my brand? Same thing in the trademark space. Why do I really need to do this? What are the benefits to pursuing copyright or trademark protection? What makes a strong trademark versus a weak trademark? Is there such a thing as a weak trademark? And did you know that there are actually state trademarks in addition to federal trademarks? And what's all that about? How exactly does Amazon's brand registry protection program work? This is something that we get lots of questions around this right now with companies who are moving on to Amazon or similar platforms that are trying to compete with Amazon. How can I get into this protective space where some third party is going to monitor my trademark and copyright rights for me? How exactly does that work? Did you know that there's customs enforcement? So if you register your rights with the U.S. Customs Office, they will actually monitor incoming counterfeits. A lot of companies don't know that and don't do that. And then how can I keep my competitors from using my own slogans or brand names or product names against me and in ads and deceiving types of information? Next slide. So basically, there are some fundamentals to IP that I like to highlight, and I'll just kind of run through these. The first is intellectual property is not intellectual. Don't let the intellectual part of that confuse you. It's a derivative of property law, and so I like to use the backyard as an analogy here. So most people understand the concept of a backyard. You've got some sort of rights in your space that's your backyard, and all intellectual property registration is, and identification and commercialization of IP rights is sort of building your fence and identifying where your property rights are and where you can keep people out. And so it's a derivative of property law. So once you understand that basic concept, a lot of the other aspects of IP are fairly intuitive. Intellectual property is not about the mind necessarily. Sometimes IP rights can establish while they're in your head. The patent space is a good example of that. You can actually develop IP rights conceptually in your mind before you ever have any sort of prototype or product. And then somebody else who comes in and infringes, they may have to be on the hook when you were never even in the marketplace. And like I said, intellectual property is about property. This is a property right. This is a valuable asset. So when you are getting off the ground, trying to decide, you've got limited funds, how do you spend that money? What's important? Intellectual property, this is a business asset, just like any other asset. It is a property right that can be infringed. Next slide. 4 basic categories of intellectual property: copyright, trademark, patent, and trade secret. Here are some images you might associate with those 4 categories. I'll just kind of hit the highlights here because, like I said, we're talking about concepts and a little bit more. And then Lauren's going to give us some really cool case studies that kind of exemplify what these rights are all about. Next slide. So the first step in pursuing any sort of IP registration or enforcement of rights is understanding what's your baby. Trying to really look into what's this creative thing that you've developed or this innovation. What rights do you have? What do you need to protect? So up top there, that's a patent illustration. It's one of my favorites. This is from everybody's favorite do no evil company, Google. This patent is actually flypaper for the car. So basically, autonomous vehicles, what's the danger in autonomous vehicles? Well, they can hit people. But that's kind of bad. But even worse is they can hit people, and those people can fly into telephone poles and get hurt even worse. And so this technology is actually by Google about flypaper for the car, so that when an AV hits a person, that person's going to stick to the car and not fly off and hit the telephone pole. You never know what Google's up to. Some of the things they do are just sort of inside jokes. So no idea if this is relevant at all. Down at the bottom, Kendrick Lamar there, very creative work, right? He's establishing lots of copyright rights through writing music, through performing music, through production of music, through production of videos. So a whole bundle of copyright rights there. And then an ear of corn, that could have patent rights, trade secret rights, trademark rights, and copyright rights. So the first step is just trying to figure out, what all do you have here? What all can you pursue and protect? Next slide. Okay, so first thing we're going to touch upon is trademark. This is possibly my favorite category of IP because you can get really creative in branding your company and your product, and it is really visceral. You take a lot of ownership in how you brand, and so our clients tend to really care about trademark rights, and it's a fun practice area. So trademark rights apply to names, logos, slogans, even sensory inputs. So the smell of Play-Doh is trademarked. So you can really trademark a lot of aspects about your innovative work. It does not include what I like to acronym here, MAD marks, and we'll talk about that in a second. Geographic marks, shotgun marks. So trademark is interesting because you can actually go ahead and apply for, let's say, a name before you ever use it. It may be 6 months before you have a product. It might be 3 years before you have a commercial product, but you can go ahead and essentially get in line to protect whatever that name or likeness is around that mark. But ultimately, you have to show that you're actually commercializing it before any rights register. So that's why I like to say shotgun marks there. What's a trademark? Essentially, it is a source identifier. So it's whatever someone can see and tie back to some person or entity that is behind that mark. Next slide. Like we said, lots of different things that you can trademark. Next slide. So here are some of our examples. A name, an acronym, a slogan. So these are all things that you can think about in terms of how you want to brand your business. Next slide. Who trademarks out there? So I just kind of pulled together this list, and there's something I want you to pull out of this list. So the companies at the top there, Rogue Ales, this is one of my favorite breweries out of Oregon. You might think, well, hey, they probably do a lot more trademarking than a Bank of America. We all know Bank of America has been around for a while, but still, that's a big gap there. When you go down this list, it's kind of interesting because the companies who trademark a lot tend to be in pretty conservative industries. And the reason why they trademark so much is that they're constantly kind of branding new aspects of their business, the same business. Banking. I mean, is not a lot of innovation in banking at the consumer point, but constant rebranding, constant reinvention of what that sort of conservative old business model is to appeal to consumers and to compete in their space. And so that's why you see a lot of heavy trademark activity in pretty conservative industries. Next slide. These are things you don't necessarily want to try and trademark. So your trademark needs to be a source identifier. All right. What's a source identifier? Well, it's something unique. It's where somebody can see a graphic or a name or a slogan and tie it back to somebody. If you're using pretty generic words like best, that's not really going to get you much trademark protection. So really think about, what's unique about your brand. Next slide. Oh, and by the way, on that last slide, so those are filings in the trademark office. So over 21,000 filings with the word best in it. Okay, back up to the graphic. So here's a little trademark EQ. We've got an article about this on our site. So rad trademarks. Rad trademarks are the best kind of trademarks. Those are the really random, arbitrary, disconnected types of marks. Your Google, Amazon, Uber, those are really strange words for what those companies are actually engaged in. When you have a very, very random word and grow a successful business around that really, really random word, then your trademark rights can really expand into other spaces, unlike some other types of marks that are just kind of more suggestive. So here's an example. If any of you were to walk into a store and see a Google microwave, you're immediately going to think that that's the tech company Google that's now into making microwaves, and maybe be a little bit terrified about what Google's doing to your food. So that would be an example of a rad mark. Everybody's going to think, hey, that's the Google we all know as the tech company who's doing that. Whereas if it's a little bit more of a suggestive mark, well, you might not know. And if it's a really just merely accurate and descriptive mark, like Paul's Popsicles, then you're going to have not as much reach behind that mark. Next slide. So how do you infringe a trademark? So there are three primary ways of infringement: likelihood of confusion to source identifier. Here's an example: is Mountain Dew made by Pepsi? Likelihood of confusion to the relationship. So, I see this name being used by this other company. They must have permission from that big, well-known company to do that. So, I guess Pepsi signed off on a parody of Mountain Dew. They must have. Dilution. This is where a company might come out, young upstart company, who is kind of reckless, doesn't really have any credibility behind what they're doing. Maybe they're doing it in an offensive way, and that can dilute another company's trademarks just by virtue of the association, the confusion, the sort of dragging down of that standard bearer mark. Next slide. There are differences between copyright and trademark. Sometimes they overlap. So a good example would be a logo. You could both copyright and trademark a logo. Different terms of rights that apply, different obligations in terms of how they have to be used, and different ways of securing damages from somebody else who might be an infringer. Next slide, please. So copyrights, those are the types of fine arts, digital designs, software, because of some lobbyists in the 80s who said that code is creative, and organization of data. It does not include data itself, factual information, names, slogans. So the data thing, I think, is important maybe for some of you. So here's an example. When you go to check into a medical provider and you get a little tablet and have to fill out your information that then goes into some EMR system, the way that information and those inputs are organized, that can be protected. There are actually lots of legal disputes in sort of the EMR space around how companies check in patients and how those user interfaces look, even though it's organization of data and data itself is not protectable. I come from a biotech background, and you see some differences among countries and continents. So in the US, bioinformatics, that raw genetic data is not protectable under copyright, whereas in Europe, some bioinformatic information is protectable under copyright. So there are differences around the world in how this plays out, but generally in the US, raw data and factual information is not copyrightable. Next slide. Copyright trolls. Here's an example of what a copyright troll is. So in the music space, the business model has changed recently. So once upon a time, when I was a kid, we bought CDs. And those CDs, you purchased it, you own that CD, you played the music. Publishing companies made a lot of money that way. Then we got into streaming, and now streaming is ubiquitous. And so the business model has really changed. It's been great for independent music producers, hasn't been so great for the traditional music houses. So What we're seeing now is a lot of activity around kind of shakedowns, for lack of a better word, where these publishing houses will actually send employees or agents or commission-based independent contractors out to bars to listen to what's being played, either on the stereo system at the bar or live. So let's say you're a bar and you host an open mic night, and somebody comes in, you have no idea what they're going to play, but they play a couple of tunes that are actually registered. They're maybe radio tunes, and somebody from one of these publishing houses is out in the audience. You can bet that that bar is going to get hit with a demand letter or a threat of suit. So we're seeing this a lot, and this is just an example of when you have copyright rights, you have very, very enforceable rights. Let's say you have some proprietary pictures, you have some good photography, and you find that somebody has taken one of your photos and has used them on a different website. Well, you have minimum statutory damages. So you could go and threaten that person that you're going to sue them in federal court. And if you do, and it's pretty clear that they took that photo from you and used it on their own site for commercial gain, it doesn't matter whether they made any money from doing that or not. They're going to be held to minimum statutory damages, which could be tens of thousands of dollars. So copyright is kind of like a sledgehammer. Your rights in copyright, they're relatively cheap, they're relatively easy to get to register your rights, and they can be used very well for your company. Next slide. So we kind of talked about this. These are examples of what types of works are copyrightable. Next slide. Now we get into patents. So I'm a patent attorney. I come from biotech, like I said, lots of activity around medical devices, therapeutics, diagnostics, that sort of thing. The patent program, if you will, protects the widgets, the things that have some sort of functionality, some sort of novel functionality. That might be processes, could be patterns, how the surface area of a technology looks. There are lots of patents in smartphones, for instance, how smartphones look. New applications of existing technology. So if you find some off-the-shelf technologies and you put it together in a new way, that itself could be patented. And the reason for that is that the whole idea of the patent system was built around furthering American technology. Old Jeffersonian concept of, hey, we don't want you to lock up your secrets behind your agricultural technology. We want you to share those with everybody so that we can all learn from it, and we can create new technologies and better technologies, and everybody can advance. And in exchange for that, we're going to give you a limited monopoly. So America, we just started up. We don't really like monopolies. That's an old British thing. But we're going to give you, the federal government's going to give you a monopoly that you can enforce against others in exchange for sharing your idea with the rest of the world. And so many aspects of patents go back to that original foundational concept of sharing it with the world, making sure that you've disclosed what this new thing is and how it works, how it's different, how it's novel, innovative compared to past technologies. So you have to distinguish that, hey, if you're going to give me this quid pro quo, you're going to give me a monopoly, I need to show you, federal government, that this thing really is novel, it's really new to these other things out there. So even if you've got some stuff that's already known out there, I was the first to put them all together in this way and create this new machine or device or process. And therefore, you can give me that monopoly. It doesn't include make-believe, natural phenomena, obviousness. That's a technical term in the patent space. That is where the patent office might say, well, you combined all these things that are known, but the way you combine them wasn't really innovative. It's just sort of an aha moment, but really anybody could have done that. The make-believe sort of natural phenomena space, that's something that we're wrestling with a lot in patent practice. So over the last 10 or so years, we've really seen a shift in the patent law to where a lot of digital technologies A lot of life science technologies are no longer patentable that once were. And the law has basically changed to say if you're just sort of digitizing something that might otherwise be known, or if you're just examining or exposing a natural relationship, say for instance in the biotech space, then that in and of itself is sort of a natural law. You can't patent that. And so I like to use the example of the little commercial that you might have to watch before seeing a YouTube video. So once upon a time, that was patented. The idea that, hey, you gotta watch 15 seconds of an ad before you see your content. Well, when the law changed, those patents were invalidated, except the aspects of them that were technical solutions to technical problems. So the concept behind them was not patented any longer. That part of the patent family was invalidated. The technical solutions that they presented to overcome those limitations and to be able to integrate those types of ads based upon user profiles who are visiting the site, those were upheld. So that's just an example of kind of where these fine lines are drawn oftentimes. Next slide. So what is important about your patent rights? Well, the feds, they're surveyors, they're not fencers, okay? They come in and they're gonna survey your land and tell you where your boundaries are in your backyard, but it's up to you to build your fence. You've got to be the one to build the fence and to monitor against others who might be trying to come into your space. And like we said earlier, with things like Amazon brand protection or the customs office, there are ways that you can get third parties to do some of that surveying for you, but ultimately it's your responsibility, whatever your IP right is. For patents, it's all about the claims. It's the claim set that matters. So if you were to see a patent, you're going to see a whole bunch of stuff. And it's going to be, maybe you find a 50-page patent and 48 of those pages are description of the technology and some drawings. And there are 2 pages of what we call claims. Those claims are the definitions of what your space is. And so it's those claims that people assert against others for infringing. And the last thing here, the patent space, while it's extremely, extremely critical in some industries like the life sciences, because you have to invest so much money into a potential therapeutic, say, that has to go through regulatory approval and clinical trials and everything. It's absolutely critical that you have patent protection. Some industries, it may not be the best option. It really is the time and money track. We actually have more patent filings in the US from China than we do from US inventors now. That recently switched the last few years. So the patent office is way, way backlogged. It's taking about 6 years on average to get a patent. There are ways that you can kind of fast track and strategize about how to get a patent faster, but it's the long road and it can be pretty expensive. So something to think about in the patent space. Next slide. All right, and trade secrets, I'm going to kind of wrap up here. Developing a good trade secret program is really about using lots of contracts and limitation of information. So the classic examples are, Coca-Cola and the KFC recipe, which I think is KFC. It's in a vault with lasers around it. Look it up. It's crazy. But thinking about ways to limit access to sort of the secret sauce, what's under the hood. And you can do that effectively through policies and contracts within your organizations and with third-party vendors who may be involved in the manufacturing of whatever your innovation is. Next slide. Again, keep it contractual and limit the norms around trade secret rights. Next slide. I get this question a lot. Hey, well, what about LegalZoom? What about some of the automation that's out there? The things that I can just kind of go and click some buttons and they're going to do it for me. It's going to be a lot cheaper than working with an attorney. So here's an example from a LegalZoom patent filing. If any of you have actually seen patents, you're going to know that this is a little bit odd that you would have this kind of hand-drawn image around a disclosed technology. And that's because you're not actually dealing with attorneys in LegalZoom. They basically create a platform for you to file yourself. So they're kind of creating an organizational tool for you to file yourself. And nobody's sitting there saying, this probably is not such a great idea. Next slide. Another example from LegalZoom. I highlighted the part that says, this is a poor man's patent, okay? You don't really want to, first of all, you don't want to have anything handwritten in your patent disclosure. And you also don't want to give the patent examiner a heads up that you consider this a poor man's patent. So just food for thought about LegalZoom and some of these other platforms that are out there. Next slide. Okay, and I like to throw some founder tips out there before I'm going to turn it over to Lauren, who's going to give you some really colorful case studies. So you're going to have to pivot as an entrepreneur. At some point, you're going to have to pivot. Things are not going to go your way. You've probably realized that in life. You're going to have to change your company, the way you operate, whatever your business model is, and do it purposefully. Figure out what your pivot is. Do it strongly and do it with meaning and do it with purpose. Understand who works for who. Whenever you're dealing with contractors, be sure you're getting all the rights that you need to. We see this oftentimes when young companies are outsourcing different aspects of their business, whether it's, hey, we're going to have this consumer product. We want you to develop the whole brand and packaging around it, but failing to get all the necessary rights to make sure that they can go forward with placing that branding in different channels. With if they need to sell the company or raise money around the company someday, it's going to come up in due diligence. Oh, you paid this third party to do all this work. Do you have full assignment of IP from them? That's important. You need to understand who's working for who when you're out there dealing with different contractual relationships. That applies to independent contractor individuals and employees as well. Leave the organics to Whole Foods. Like we get this all the time with founders. We've done this, we're old friends, we're brothers, we're sisters, we're engaged. We do this on Handshake. We don't have a contract. We think that might kind of mess up, how things are. Don't do that. We've been involved in so many disputes that originated from a lack of having any definition around the relationships. So, just introduce a little bit of formality into your friendly relationship, because you never know what's going to happen. You never know what's going to happen to one of you and the people who may inherit rights or responsibilities by virtue of your death or incapacitation. You don't want them just kind of stuck out in the cold. So don't get too organic on this. If you're a social enterprise, remember it's about the value present on the front end, and people are going to consider working with you for your virtue on the back end. So always lead with the value proposition. SEC, that's not just a football league. The Securities and Exchange Commission is real. When you are dealing with equities, what is an equity? Any interest in your business that you promise to a third party for some sort of consideration, like for instance, a service or money more often, in which that party is passively depending upon you to generate income for them. It's an investment. It can be in an LLC as well. It's not just about corporations. If you get into that, you have to understand that is a highly, highly regulated transaction at the state level and the federal level. There are obligations for you to file certain forms and disclosures, for you to be working with certain types of parties, a certain level of sophistication around the investor, and recognizing that you have some obligations there. And finally, you're in a safe, risk-tolerant place. The U.S. is pretty awesome for being an entrepreneur. Seen some other places, have hosted delegations from lots of other countries in which they were exploring the U.S. and the entrepreneurial ecosystem and trying to develop a Silicon Valley back in their country. And one of the hangups was, well, we're not a very risk-tolerant society. If you mess up, that's a black mark. That may be the end of your entrepreneurial career. In the US, hey, look, you can mess up a lot and you can still hit a home run. So even if whatever you're doing doesn't sell at the end of the day, doesn't get you a lot of investment, go back to the drawing board, take another at bat. There are a lot of opportunities to learn from that first failure and to be successful at the end of the day with maybe a different idea or a different approach. So next slide. So that's my kind of overview, and let's welcome Lauren. She'll tell you a little bit about herself and how to apply some of these different aspects of IP.
Hi friends, thanks for joining us today to talk about IP. My name is Lauren Hughes McClanahan and I'm the Intellectual Property Lead at Rockridge. Next slide, please. I'd like to add some practical guidance to the knowledge Kevin shared today and tell you a few different real-life stories where having an IP strategy in place really helped different companies reach their goals. And on the other hand, where a lack of strategy led to some financial hardships. I think it's important for all entrepreneurs to consider IP at the onset in terms of thinking where you want your company and your product and service offerings to be in the future. While I'm going to change some names and product categories of actual clients to keep that confidentiality in place, the concepts are all going to be the same. Currently, we represent a client that has created a hairbrush that is one of a kind. If you use this brush, it's going to leave you with silky smooth hair and it's going to run through tangles with minimal pooling and without any damage to the hair follicle. This company calls its product Swish, creatively playing on the sound of a hair flip, which, if you're listening to Kevin, makes for a great trademark, so long as no one else is using that mark for the same products. And no one was. But as this startup grew and its Swish brush became more popular, it wanted to expand its product base into other hair care products, like curling irons and detangler sprays. Unfortunately, there was another company called Swoosh that was already selling some of those other products, like those detanglers and shampoos. Swish and Swoosh for hair care are relatively similar for consumers in that those marks are going to be confusing. When our client was selling Swish at least 2 years prior to Swoosh, it didn't enter into these other product categories until after Swoosh had become established. So Swish could not use its hairbrush trademark registration to prevent Swoosh from operating in the hair care market. It could have filed an intent to use trademark application to reserve that trademark for those down the road product categories. But by failing to strategize early on, it found itself being forced to share the market with Swoosh. Even so, things could have been worse. Had Swoosh filed for a federal trademark application in those product categories before Swish decided to expand its product line, the Swish line of products could have ended with the hairbrush, but Swoosh never filed a trademark application, so Swish was able to share that market with them. Swish and Swoosh are great examples of how a forward-thinking trademark strategy can enable your long-term growth. Similarly, if your company is considering physical expansion in addition to product and service expansion, a well thought out strategy can serve your best interest. One of our record production clients found himself only operating in his home state. So he didn't really feel a need to immediately seek out a federal trademark registration, which would have given him nationwide rights in his name, as opposed to just rights within his operating territory. A couple of years went by, he was able to market himself in a number of surrounding states and grow his business. He reached out to me about getting a trademark for his name, Bunny Hop Productions. Unfortunately for him, when I did a trademark search, I saw that another music company was calling itself Bunny Hop Records, and they had filed a trademark application just a couple months earlier. Although my client, he had heard of Bunny Hop Records, he didn't mention them to me because he thought it's not going to be an issue since their services were slightly different than his own. He produced music and the other company acted more like a talent agency. But he wasn't able to get the registered trademark, and that prevented him from scaling his business further since the other company already had a registered trademark, because now he's stuck to operating only in the areas where he currently was. While a federal trademark registration can offer protection within the United States, many of our clients find that they intend to grow on a global scale, and they need to consider international trademark filings. Nearly every country has its own trademark office, most of which are organized by the World Intellectual Property Organization, known as WIPO. Once you file a US application, foreign applications can be applied for through WIPO in all of the countries where your company intends to expand into. One problem we face is international copycats, and even large corporations deal with this issue. In 2000, Starbucks found itself entering into the Korean coffee market at the same time as another coffee company called Starpreya. Starpreya was using a logo that was eerily similar to Starbucks mermaid within a green circle logo. In that Starpreya, they had the green circle. It had Starpreya at the top in white and coffee at the bottom in white with the little stars in between. But instead of having the mermaid in the center in black and white, they had a black and white Greek goddess. So it was slightly different, but pretty much the same. So Starbucks did not file for a Korean trademark application prior to Starpreya entering into that market. Instead, Starbucks had to rely on its common law rights, those unregistered rights that exist only through consumer recognition. The problem was, outside of the United States, no one was familiar with Starbucks. So after a decade of legal proceedings, that coffee giant was declared a loser, and Starpreya was allowed to continue using the knockoff logo. There is a lot of time and money that goes into creating a brand. Not only can an IP strategy help you protect that, but early clearance searching can prevent you from backpedaling on that work. Because a registered trademark gives a nationwide presumption of ownership, a useful tool if you're a trademark owner, that could also stand in the way of you creating a brand or naming a new product or service line. Before launching a new line, a company typically bears an upfront cost burden of creating a website, creating a logo, and designing all of those marketing materials. Then there's the launch. And if a competitor with a confusingly similar name with a registered trademark notices you on the market, and they will, because that's the purpose of your marketing team, they're immediately going to send you a cease and desist notice. And you're not going to get a refund for all of the money you spent in creating that product line. And that other company, they can demand that you hand over any domain names that you purchased, or if you're selling products with your logo or name on the products or packaging, they may not even let you sell out of that inventory that you've stockpiled before switching your name and logo. Some people can be pretty cruel about it. And if you don't comply with their request to stop, they could sue you, and they're likely going to win because of that power granted by their registered trademark. So to prevent this disaster scenario, we recommend adding trademark due diligence to your launch plans, preferably before you've sunk in too many costs in the project. What we do is identify any hurdles to trademark registration and mitigate risks that you might face after filing your trademark application. If a confusingly similar name is already being used on the market or is being reserved by the trademark office, we'll let you know about it. And we'll also strategize with you on how to move forward. Shameless plug aside, I really do hate getting those calls from someone saying, I just got a cease and desist letter. How can I recoup all my cost? A lot of times those phone calls are the first time they've spoken to a trademark attorney. And at that point, there's very little they can do in order to respond to it. When clients do come to us first thing, we're much better positioned to help you in strategizing growth. Here, I'd like to talk about two of Kevin's favorite case studies, the Gravity Blanket and Beanie Babies. Next slide, please. So the Gravity Blanket is the product name for a company's weighted blanket. Weighted blankets themselves had been on the market for a while, only they were exclusively marketed to children with anxiety. These weighted blankets are made with pockets filled with tiny little beads, making them feel heavy. And the pressure of the blanket kind of mimics a full body hug, and hugs release serotonin, which gives the hug person a sense of calm. So this design group out of New York was familiar with weighted blankets and thought that they would be able to sell those to adults. So they created the gravity blanket. Because the idea itself of the blanket was not novel, they couldn't get a patent, but they created this Kickstarter strategy that focused on the name gravity blanket, which is pretty imaginative for a heavy blanket that brings anxious people back to earth. With a cool marketing video, they released the name gravity blanket into the world, and their Kickstarter campaign, where they asked for $10,000, they easily were able to raise $4 million because of the creativity of their marketing. They simply took an existing product, marketed it to a new crowd under a clever name, and they were able to make their product into a household staple. And as follows fame, a Hong Kong holding company soon after attempted to file for trademark protection on the name Gravity Blanket, despite knowing it was created by the New York design company. That is trademark trolling, as Kevin referenced. Luckily, that New York company had already preserved their name through filing a trademark, and the Federal Trademark Examiner used their registration to deny the application of the Hong Kong company. So they didn't even have to worry about them themselves. I've spoken a lot about trademarks, but as Kevin mentioned, there are various forms of intellectual property like patents and trade secrets and copyrights. And these forms of IP are also going to rely on strategy to increase their potential and their value for companies. If you're a 90s kid like me, then you're going to be very familiar with the heart-shaped tie tag and emblem-chested squishy animal dolls called Beanie Babies. Ty had invested in the rollout of its toys and wanted to prevent other toy makers from creating these similar pellet-filled animal dolls. But the idea of beanie bag toys was not patentable, and there wasn't any clever trade dress protection available. So Ty looked to copyright law, and they submitted applications for its toys as sculptural works. A toy being a sculpture seems a little funny, but Ty was able to use this copyright registration to aggressively go after other toy makers looking to create beanbag toys. In one lawsuit, Ty accused another toy company of copying its pig Beanie Baby, Squealer. And because the copycat pig looked more like the sculptural work Squealer than a real pig, Ty won. So this kind of aggression can be a very useful tactic in intellectual property law. Every time you let a confusingly similar mark or creative work reach registration, your intellectual property is going to diminish in value just a bit. Other trademarks, like I mentioned earlier, can prevent you from entering new product categories, but they can also take away from brand value in that consumers are going to alter their purchasing habits based on what they believe your company is offering. Two great examples that have extremely aggressive trademark strategies are AARP and Monster Energy Company. Monster holds a trademark registration for the letter M, and that looks like a claw mark. And you're going to see that on its energy drinks. However, because Monster is so aggressive and chases down every single trademark applicant that files any form of stylized M, Monster has essentially expanded its protection, not just to M's that look like claw marks, but to all M's in general. Now, the only other M's that you're going to see on the market are M&M's, which came first, so they can't be stopped. AARP does something similar in that it won't allow any other organization to use a similar acronym, whether it's AARP, ARP, or AAP. From its efforts to increase the value in its trademark by reducing similar marks in the market, AARP is able to gain a tremendous value from licensing its IP, and it earned about $1 billion in licensing profits in 2019 alone. Sometimes this aggressive strategy approach can benefit your company not just by building value, like I've been talking about, but by decreasing negative affiliations. Recently, and I'm sure you have all heard by now, this investment company, Robinhood, let some of its users down by preventing them from trading on GameStop stock after an unprecedented increase in value that followed this Reddit group attempting to undermine Wall Street hedge funds that had bet against the company. Now, several other companies operating under the name Robinhood are bearing some of the brunt of these upset consumers, and the hate is freely flowing between them all on social media. Some of these other Robinhoods are nonprofits, and they're finding that the falsely associated bad media is really hurting their missions. Would you go back one? Oh, thanks, Bruce. Before we leave you today and take some time for questions, I wanted to share with you one of my favorite stories, which really speaks to a key aspect of IP protection that all startups and companies should implement, and that is protecting through contracting. Contracts are a convenient way to clarify early on understandings that can be muddled over time. So when a co-founder builds out part of an app, he might assign that creative work to the company rather than retain ownership himself. Or when a business hires a branding firm to create a logo, they need to be sure that they have an assignment agreement in place so that they themselves own that logo and not just a license to use it. My story comes from a time when that assignment agreement never happened and ended up costing a mittful. So in the 80s, the Baltimore Ravens were looking to take on a new logo from their team, and they decided to have a contest for their fans. Whichever fan created the best Raven logo would have his or her design featured on all of the gear. So this guy named Freddie created a flying Raven design and faxed it in, and that became the team's official logo. The only problem was the team never got an assignment agreement in place outlining the arrangement and ownership. Freddie didn't care. He was just glad that the Ravens were using his design. All he wanted was recognition. He created it. He wanted everyone to know. Unfortunately, the Ravens didn't want to do that, and the case went to court. Freddie won, and he got the credit. But then he thought, I've never been compensated for creating this logo. He likely thought that because court cases are very expensive. But the Ravens, who had been using that design for a number of years at this point, they didn't want to pay him, especially because they just went to court with him. So they went to court over the payment again, and Freddie won again. He got the money, he got the recognition, but then the very next season, the Ravens changed their logo. And I bet they had an agreement in place dictating the terms of that arrangement up front. So there you have it, a number of reasons to think about IP when creating your business. On behalf of Rockridge and Amplify Louisville, I'd like to thank you for joining this event. I believe we're still under time, so Kevin and I would be happy to answer any general questions you might have about intellectual property.
And I think, should we just grab some of these, or are we gonna moderate some of these?
Yeah, we can go ahead and just start answering. I can read them off to you, or if you want to just choose the ones you found. I know there's a handful of great ones. I was really excited for Q&A. And if it's okay with you, yeah, we would love to go over a little bit in time to get some of these out.
Great. I'll just run down my running list here.
Yeah, go ahead.
And the first question that we've seen a few times, will the deck be shared? Absolutely. You're free to resource the deck for looking into this further. Like I said, we've got some links there that you can go and read up more about the different topical areas. Let's see. I think we have a patent question here about if the app, which I'm assuming is the application versus an app, and let me just go ahead and address app in itself. Apps usually are not patentable. So in terms of mobile apps, we usually recommend not filing for patent protection on apps. One of the reasons is that oftentimes they fall under this, what we refer to in shorthand and patent speak, Section 101 of the patent law, which is that space of things not being patentable because they're just natural relationships. So anything that involves code or algorithms typically are not patentable unless they're presenting a technical solution to a technical problem. If the language here is about application, so let's say an application is a new technology, but using existing tech to do business differently and creatively, is that something to consider patenting? Isn't that an obvious invention, just presenting the idea differently? So you should definitely consider it. So if you have off-the-shelf components, when I say off-the-shelf, I don't necessarily mean a hardware store, but off-the-shelf in terms of readily available components, and you combine those in a new way, then yes, that absolutely can be patentable. In the pharma space, you see that oftentimes where a small molecule was used for a particular indication, and then someone discovered, oh, hey, this thing can actually be used to cure this other chronic illness, and that can be patented. Just understanding that there is a new use for it, that in and of itself can be patented. What happens sometimes is you create blocking patents. So maybe you are able to patent the combination of those elements for some new use. Maybe you can get that patented, but you may still have to license the underlying rights from all the upstream patent holders, if there are any, to be able to combine it in that way for a new use. So they can't, if there's an upstream patent holder to a component of this new combination, you've suddenly blocked them from being able to do that with their patented technology, but you can't necessarily do it even if you can get a patent without a license from them. So you get into some complicated patent families in that scenario.
What type of patent would that be, Kevin? I mean, that's a great question, because oftentimes nowadays there's not a whole lot of new inventions. It's maybe minor alterations or reapplications. That's a great question. I'm curious, how different does the product need to be made to show that it is different from the original patent?
Right. So I like to break it down to a very elementary example. So oftentimes I use the sort of idea of a three-legged chair and a four-legged chair. So let's say you're sitting around on logs, and somebody comes up with a brilliant idea of, hey, here's this, I have this new invention. All right. So I'm going to create this platform, and it's got a back to it. And you're going to sit on this thing, and it's got these protrusions coming down to the ground from that platform. There are three of them. I call it a chair. And so I'm going to file a patent application on that. Everybody's been sitting on stones and logs, so nobody's ever seen anything like this. Your patent flies through the system and it gets awarded. So everybody's big on using the three-legged chair. Suddenly nobody's sitting on logs and rocks anymore. Somebody comes along and they say, that three-legged chair is pretty cool, but I think if I add another leg to that, it's going to be more stable. And I bet people are going to prefer the four-legged chair over the three-legged chair. I've seen some people fall off and tip over, and I think I can help prevent that. So you come along, you stick another leg on that chair. Whether you can do that or not in the first place is going to be determined by the language of that initial three-legged chair patent. That three-legged chair patent, it might, in its claim set, when it's describing the technology, say just consisting of three legs, or it could say comprising three legs. And comprising is a magic word in patent land. That means this many and anything additional. So if that patent says comprising three legs, then that applies to however many legs you want to stick on it. And so some of it goes to, if there's something out there that's already patented, how broad is that claim set to the patent? It may cover a lot more than just what you're seeing out there in product land. So that's one consideration. The other consideration is, let's say none of that's patented or it's long ago not been patented, then the innovation, like a lot of stuff in law, is governed by a multi-factor test. And so you can show, let's say you file a patent application and you get hit with an obviousness rejection. That's that rejection that says there's stuff out there. I found an academic journal article in Russia, and I found a product in China, and I found a website in the US. I'm going to combine all that, and voila, I have what you have. That's an obviousness rejection. There are ways you can argue against that on this sort of multi-factor test. One way to argue against that is if you combine something and you start selling it and it just blows up and you've got tons and tons of orders and sales as soon as you go to market, that's one thing you can use in arguing to the patent examiner that, hey, it's not obvious because look at all this, the market responded to this. I mean, we're selling these things like gangbusters. I mean, everybody wants it. That's a clear example that we've achieved some sort of innovation in how we've put all these components together. So I don't want to spend too much time on that, but those are a couple of examples.
Yeah, thank you for that. That's a great, so it's the wording and the fencing you create. So that's perfect. Thank you so much.
We have another question here. I'm jumping down the list a little bit, asking when you do a trademark search and you find a reference, but the live dead indicator says that the mark is dead, what exactly does that mean? So the live dead indicator doesn't necessarily mean that no one has a trademark in that mark. It just means that they don't have a registration in that mark anymore. So as Kevin said earlier, you have a trademark at the moment of creation. You get more rights to that trademark when you register it. So they either let their registration lapse or something happened with their application, but they could still have common law rights to that name. And if they're operating within your territory or territory you want to be, or maybe they're operating online, so they might be, everywhere, they could still send you a cease and desist letter and prevent you from using that name for your own business.
Yeah, and I'll just piggyback that. And as a reminder, there are both state registration rights and federal registration rights. And while it may be unlikely that a company allowed its federal registered trademark to lapse because they didn't pay a maintenance fee or something, and their state registrations are still maintained, it is possible. And so you might still be violating state-held trademark rights, and those are fully enforceable just within the state that they're registered in. So just like federal trademarks, you have all the kind of ammunition and the claims to assert against somebody just within a particular state.
We've got another question here. How do founders protect themselves in a joint venture? For example, one founder has all of the technical expertise and one has the business acumen. What type of arrangement can they make to make sure that one party doesn't leave the company with all of the IP? So this sort of situation can be handled through contracting, and there's different kinds of contracting that can come into play. So you can have a founder's agreement, you can have an operating agreement or bylaws, just telling business owners how they're going to manage the business. What happens when they create something? Is it automatically assigned to the company? That could also be contained in a separate assignment agreement where the founder is giving up anything they create to the business. So the business is now the owner, or if they ever leave, they're going to give it up. And also, kind of discussing how decision-making is going to be done. And if one founder leaves, then the other one can buy up that other founder's rights, including that intellectual property.
Yeah, and I briefly addressed a point about licensing in the Q&A, but also non-compete provisions. So we regularly deal with non-compete clauses in contracts where maybe somebody has left an entity and they are competing with the entity, or maybe someone wants to secure the services of someone who has an existing non-compete arrangement with a third party. And so you could also limit your joint venture partner through non-compete provisions. Now, non-compete provisions, just because you have a non-compete provision somewhere does not necessarily mean that it's enforceable. And so a lot of the practice around non-compete means looking up how different states have limited their non-compete statutes or expanded their non-compete limitations within court cases. And it really is a state by state basis for that.
Kevin, I've got a patent question for you here, and I think it might be alluding to provisional patents. I heard that an idea could be patented for maybe about 6 months. Is that still the case? Anything changed?
I think what this question might be referring to is a provisional patent application. A provisional patent application is kind of like a baby patent application. It's where you're essentially getting a placeholder with the patent office. So you put together your disclosure, the specification of your invention, how it works, even if you don't have prototypes, as long as it's formed in your head enough that you can explain it to somebody else who is within the same sort of mechanical art and they can understand it, that's grounds enough to file a patent application. So the provisional application does not have all the components of a full-scale utility application, but you have to submit enough to get a placeholder in line at the patent office. And what the patent office says is, we're never going to publish this. We're never going to disclose it. You've got a year within which to convert this provisional application to a full-scale utility application. And if you don't do that, it's going to abandon. It'll never be published. Nobody will ever see what it is you're trying to do. If you do convert it, then 6 months later, it's going to publish. So everybody's going to see it. But when you file a full utility application, your rights go back to that initial filing date. So essentially, it gives you some time to sort of iterate your idea, to test market your idea while you have that protection, and decide whether you want to go all in and whether you want others to really know what the secret sauce is of your idea. So that's what the provisional process buys you. Now, a few years back, the law changed around provisional patent applications. And there's a lot of fear in the patent sort of practitioner space that your subsequent application had to be exactly like the provisional application. So before the law changed, what you saw was a lot of really minimal applications being filed at the provisional stage, like maybe a 1 or 2 page provisional applications, maybe a manuscript for an academic article, and then a subsequent fully formed patent application. When the law changed, those disclosures have to be much, much more similar. So your provisional application really has to be spelled out pretty well. It can't just be a series of flowcharts and diagrams or a manuscript. It's really got to be in the form of an application. But you do have some wiggle room to kind of iterate, to flesh out some of your ideas and your concepts, to generate some data to support that initial disclosure. And I think that's what the question is referring to in terms of a 6-month patent. It's really hard to get a patent within 6 months. You can pay to play. Essentially, you can pay the patent office to accelerate review of your application with a separate fee that can be quite expensive. And that will get you a patent faster, whether it's a design patent or a utility patent. So what are the strategies that we have in filing is actually co-filing a design patent with a request to fast track it and a provisional patent. And so what will happen is that provisional patent application will go to the patent office. They'll check it to make sure it fulfills the requirements of filing, but nobody's ever going to examine it to see whether it can be issued as a patent. But that design patent application, when you pay the extra fee and you petition and they accept it to be fast tracked, if it can be issued, it's going to be issued within 6 months. And so you're going to come out of that knowing whether there's a good indicator that whatever your idea is could be patented. So it's a good sort of combination approach to sort of testing the waters a little bit and maybe getting an early patent. even though generally design patents are not as strong and enforceable as utility patents. But that is one good strategy. So that might also be what the reference is to sort of 6 months.
Kevin, we've got another patent question here, and I think it's alluding to whether a common law patent exists. So it asks, what if you create a unique process, we're not able to afford patent registration? Are you protected by being the first to create it or use it?
Very likely not, unless it could be protected by trade secret. So if you go out there and you disclose it and you haven't filed for it, then you're not really going to have common law rights like you would with copyright or trademark. You just don't get those rights. There really is a requirement that to get the registration to have enforceable patent rights. But again, let's say it's software. You might have some trade secret rights against, for instance, reverse engineering, if you have really protected it in a way that would secure those trade secret rights under state law. So generally no, but potentially is trade secret.
This next question is, how can I get an IP strategy? Because this is new information for me. Every time Rockridge takes on a new client, we always have a business and IP strategy with them up front before we file a single thing or draft a single document, just so we can understand where the owners are wanting to go with the business and how we can help you upfront and strategize right from the onset of that relationship. And then a lot of times, as our clients and their businesses grow, they'll need to continue to strategize with us. So every time they come up with a new idea, I'll get an email saying, I want to talk to you about my next crazy idea. And I just love those conversations.
Really quickly, we have several, I think, patent questions. I'm fine to stay on for another 15 minutes. I'm not sure about Lauren, but I'm fine to stay on. Lauren, if you need to go, you can knock out any of the other questions around general IP, and I could stay on, or we could just stay for the party. But we will address these questions before we go.
No, I'm having a good time. I'm glad to be here with Amplify and all its members, and thank you all for such great questions. We really appreciate your attendance.
Yeah, thank you so much, Lauren and Kevin. This has been an awesome session. Yeah, I don't want to take too much more of your time because I know we could go on for hours with questions, especially on patents. Very elusive subject. So we're so thankful to have you today. And maybe we need to do a follow-up session for sure. But yeah, if you have more time to answer a few more questions, we'd love to hear your knowledge.
Well, I like to pose all of the patent questions to Kevin because he is our patent attorney here. Why I like to take on copyright and trademark and contracting and also share those with Kevin. So our next question does have to deal with patents. And the person asked, is it suggested to get a patent search done professionally or a patent before launching a Kickstarter?
So let me address that question this way. When you disclose your idea, you lose certain rights if you've not filed a patent application yet. So the clock starts ticking. We have within the US a 1-year grace period. So let's say you didn't file a patent application, but you put your invention out there for the public to see and to see how it works in particular. Then you've waived all rights to any sort of overseas patents. You've waived the ability to file within the PCT and to get any patents in Europe or China or South America, anywhere like that. You still have a grace period within the US in which you can file and attempt to secure those rights even after you've disclosed it. But we are in a first to file system. So if somebody else were to file before you, they're at the front of the line. So I always recommend if you have something that's, it's got some moxie to it and you think it can be patented, then yes, you should do that before it's ever thrown up online and archived and can be found, because if you leave a crumb trail, if you leave a paper trail, it can be used against you. People can anonymously submit that information to the patent office to say, hey, this was disclosed before they filed. And so, you are running a risk. Let's go to our friend Timothy in Nashville. Hey, Timothy. Timothy has a SaaS company, and he's asking a question about budgeting for trademark and IP and kind of how to approach that. And it's a great question around branding strategy. And so I'll toss it over to Lauren.
Oh, great. So when you're talking about budgeting for a tech company, basically all a tech company is IP. So you're going to want to protect that to prevent copyrights from coming into the market. So it's really not a flat fee that I could give you. It depends on how much intellectual property you hold, how many things can be registered as copyrights, how many things do you have that can be registered as trademarks? Do you have any patentable material? Are there any trade secrets? Do you need contracts in place between your vendors, your clients, your employees, your independent contractors, your founders themselves? What about privacy? Are you collecting data, and do you need to protect that in a certain way? So what we're talking about is not a flat fee cost for budgeting, but it's more another sector of your business as legal and intellectual property, especially for you as a tech company. Starting out, one trademark filing, depending on how many goods and services you're wanting to incorporate within that application, you might be starting somewhere around $1,500. But as you add other trademarks into that portfolio and other intellectual property elements into that portfolio, you can see that cost rise a little bit.
And I'll just follow up and just say, this is one thing that it's always very concerning. Companies are scared to talk to attorneys. Are they going to start? Am I going to get a bill as soon as I get off the call? I have no control over how much it's going to cost. I've heard horror stories. We're very transparent about our costs in most aspects of IP. We offer flat fees for these different services. Where the variation comes in, like Lauren was mentioning, is you're going to have different federal filing fees depending. So for instance, in trademark, well, you may want to file your application in 4 different classes of goods and services, where you're going to have $250 per pop of just federal fees. If you get an office action, you're going to have to argue against that office action. So it's hard to say kind of what an appropriate budget overall should be, depending upon how crowded your space is and how broad the rights you need are. But that's why we like to offer just sort of an assessment early on, spell out what those costs might be and kind of what you're looking at. In
working with our clients, we are very aware that we're working with startups who might be cap-strapped. So we're going to offer you recommendations of here's what you can do to maximize your protection and reduce your risk. And then understanding your financial needs, here's what you should do if you can't do everything. Here's what's best if you have to choose choice A over choice B, and kind of provide that strategy. So that way you're not spending all your money on legal upfront, but as you grow, you can come back to some of those items and put them on your list, because the ultimate goal is to have maximum protection at some point, and hopefully before it prevents your down the road growth there.
So I'm going to read this one from Connie in biotech. Ooh, biotech question. All right. Data, is that added to support the non-provisional application? Does it have to be new from your group? Sometimes there's something already published that proves your point, but the author didn't recognize or mention the principle. Gotcha. So this is to support the non-provisional application. So anything that you add in terms of the specification to a patent application, it does not have to be all your own proprietary information. And so oftentimes when our group drafts patent applications, if our client doesn't conduct that research and give us prior art to work with, we're usually researching to find some other, say for instance, academic articles out there that help the examiner to understand what the prior art is and how this new filing overcomes the prior art. You know, what the separators are, what's distinguishable, how's this thing innovative over what else is out there. And so you can use that data and information from third parties, like from the academic literature, to prove kind of what your models are. But your claims are really limited to the proprietary applications of that information, what you've done with that information. And so you can't necessarily take somebody else's process or method and incorporate it into a patent claim. Possibly if there's some innovative application of it, but there are limitations to how you can do that. So it's good to use that information to kind of set up what you've done, but it's not that the data is useful, but their methods aren't necessarily patentable if you incorporate that into your claim set. Let's see. I want to mention one more thing. So with patents, we are in a space where there were some questions earlier about patent searches, and I strongly recommend doing due diligence on the front end and conducting patent searches to understand how likely it is for you to get enforceable patent claims. A lot of times I'll come across patents that the claim sets are so narrow with so many limitations that it's just a vanity patent. It's completely worthless. It can never be enforced against anybody else. And so when we're hired by investors to conduct due diligence for potential investments, we're looking at how enforceable are these patents? How valuable are the patents? Because if they're just vanity patents, then that's going to kick down the negotiation quite a bit to say, well, you've got a patent, but we can't use that patent to create any competitive advantage or advantages against third parties because it's just not enforceable. Or you might get a patent that's issued, but it could be invalidated even after it's issued. We're in a case right now in the federal circuit where a patent family, half a dozen patents were issued just a few years ago, and they were all subsequently invalidated in federal court. So even if you get an issued patent, it could still be overturned and invalidated, which is why it's a really good decision to make the investment on the front end to conduct some due diligence. Maybe it's just a novelty search, or maybe it's a full-on freedom to operate analysis before you invest your time and energy and whole business around something that could be patentable. All right, so I think that's everything.